Good morning, Mr. Chairman and councillors of Peel Region. I am Diane Kalenchuk of Mississauga, and I thank you for your time this morning. My husband John and I have been residents of Mississauga and Peel Region since 1974. Over these many years, we and all residents have been very fortunate to have experienced the outstanding leadership and dedication of our Mayor, Hazel McCallion. As you know, Madam Mayor has served our city of Mississauga and the region of Peel for over 35 years. Mayor Hazel McCallion of Mississauga, in her capacity as a councillor for the region of Peel, successfully defended a complaint brought against her under the Municipal Conflict of Interest Act. The complaint related to motions moved and seconded and votes taken during the development charges bylaw process at the region in 2007. Having been successful, Mayor McCallion is entitled to the payment of a proportion of her legal costs from the unsuccessful complainant. Such costs were awarded to her by the Ontario Superior Court. The complainant has refused to pay on the basis that he has no assets. Having exhausted all other avenues available to her, I now request that the region indemnify her pursuant to the region's bylaw 38-2005, quote, a bylaw to provide for certain insurance and reimbursement of employees and members of council by the regional municipality of Peel. The bylaw states that the MCIA actions are exempt from coverage, but that council retains the discretion to extend coverage in circumstances deemed appropriate by council. I submit that such coverage is appropriate in the circumstances that I detail now. The complainant alleged that Mayor McCallion had a conflict of interest with respect to certain motions moved and votes taken by Mayor McCallion at our Peel Regional Council with respect to the 2007 Development Charges Bylaw. The court found that Mayor McCallion did not have a conflict of interest and that the complainant brought the application out of time. As Mayor McCallion was successful in her defense of the application, she asked the court to award her her cost of the defense. She asked the court for $394,529 in costs on a partial indemnity basis. In Ontario, except in certain exceptional circumstances, the normal measure of costs is partial indemnity, or roughly 60% of the amount expended. Hourly rates used to calculate this amount are on a tariff basis substantially lower than the actual rates charged in the region. The court ultimately awarded Mayor McCallion $170,000 in costs. The complainant has refused to honor that award on the basis that he has no assets, and he has provided a sworn statement to that effect. Importantly, the court recognized that the amount claimed was reasonable on a partial indemnity basis. The court stated that this was a complex matter, although all counsel, quote, cooperated and presented case efficiently and effectively, unquote. There were over 5,000 pages of affidavit evidence and 2,500 pages of transcript evidence relating to 13 days of out-of-court examination. There were 11 days in court. The court found that A, the costs claimed were reasonable, B, the litigation was politically motivated and did not arise from a bona fide concern for the public interest, and C, any public interest in investigation of the events regarding WCD had previously been satisfied by the Mississauga Inquiry. The court also, when reducing the amount to be paid by the complainant to Mayor McCallion, explicitly recognized, although stated that he could not take into account, that the mayor has the ability to ask that council indemnify her. Accordingly, I now ask that the region indemnify Mayor McCallion pursuant to the terms of the bylaw. If I may go over the bylaw again. The bylaw provides that a covered action or proceeding is one that is A, brought after the passage of the bylaw, B, arising out of acts or omissions done by a covered individual in the attempted performance in good faith of her or her duties as a member of council. C, in the performance of any statutory duty. MCIA proceedings are excluded from the normal coverage, but council may vote to extend such coverage pursuant to Section 19 of the bylaw. The actions satisfy these criteria. It was A, commenced in 2011 after the passage of the bylaw, and B, concerned votes taken by the mayor or motions moved in the course of her duties as a councillor of the region. The court found these acts were not a conflict of interest and thus were in good faith. MCIA and similar applications have been found by other municipal councils and the courts as properly covered by similar bylaws. Cases involving both Toronto and Thunder Bay have approved of or acknowledged the propriety of a council indemnifying its councillors where they have been successful in defeating the MCIA or similar claim concerning acts done in the course of these activities as councillors. Mayor McCallion was forced to mount a vigorous defense in this case because of the potential effect on her reputation, her career, and her responsibilities as a democratically elected mayor of Mississauga, as well as a Peel regional councillor. As such, the costs expended were proportionate with the potential impact on Mayor McCallion's reputation and career. In all, I request that she be indemnified for the total costs of defending the action, being $513,430, which is the total amount expended less the $100,000 recovered from the applicable insurance policy. I ask the council indemnifies her for this amount. Any councillor could be subject to an unsuccessful Municipal Conflict of Interest Act complaint, and personally bearing the potential extreme cost of defending such complaints could have a potentially chilling effect on those who might otherwise consider public service. I would be pleased to provide any further information for you, and I want to say that the mayor's lawyer, Freya Christensen, is in attendance this morning if there are any questions for her at this time. Thank you.
Councillor Sado.
Thank you, Mr. Chairman. Thank you, Diane, for being here. Mr. Chairman, I wanted to speak to the presentation, and I have a motion that I want to speak to, but Councillor Sprovieri, I think, has a quick question of the deputant, so I wouldn't mind him going first if he wishes to ask.
Okay, Councillor Sprovieri. I do have Councillor Miles on the list, but Councillor Sprovieri. No, I'm the chair.
Okay. Well, thank you. Thank you, Mr. Chair. Thank you for the presentation, Diane. But I do have a question, and you know, just to say off the top, the beginning, I have no problem in supporting what you're requesting at this point. But there is one issue that I have to mention. I am concerned about the public perception. If this council does what we are asking, in a council perception, it was a very publicized case, and it was very, everybody knows about it because of Hazel's great reputation, and so everybody paid attention. But everyone knows that the reason why she was. The case was dismissed is because the complaint was lodged a bit too late, and so they figured that was a kind of so the question that they was to really be cleared, and I believe that that this walk-on motion that was given to her to sign at the last minute before council, probably Hazel didn't think about the ramifications or her son or whatever was going on. She probably figured it was someone asked her to sign it, and it wasn't on the agenda, first of all. So it was a last minute thing, and she says, oh, sure, just sign it off, and let's go on to the meeting. And I believe that's what happened. So I don't have a problem with supporting what you're asking. But we also have to deal with public perception, and this has to be really made clear that this request is that the mayor was kind of, I would say, not coerced but surprised, seconding the motion, and I think that has to be well explained to the public, because not only will residents of Mississauga cover this bill, but residents of Brampton and of Caledon. So this is my comment. I don't know whether you want to touch it or... Yeah, it's a question. I don't know whether you want to touch it or whether, how we address this perception, but the public, there's going to be a reaction when when council, and I will support it, I said, because I believe that what happened was a surprise situation on her. Okay?
Before...
If I may...
Thank you. If I might, there were some factual issues about the lawsuit that it might be helpful for me to address. My name is Freya Christensen. I was the mayor's lawyer on this. I think it's important to understand, first of all, that the judge found she was not in a conflict of interest. So there were two grounds on which she won. A, she was found to be not in a conflict of interest, and B, the motion was brought out of time. So that's crystal clear. And secondly, the lawsuit did not involve just one motion. It involved all of the development charges process and all of the motions. So it was the participation in a whole number of motions. So it was the entire development charge process in 2007. And I think that's important to understand as well. So from a factual perspective, I just wanted to get that straight.
Thank you.
I'm going to go back to Councillor Sato.
Thank you. I wouldn't have given up my spot if I thought there wasn't a question, but
Thank you.
Anyway, so I'm going to speak then. Mr. Chairman, I came here this morning prepared to move a motion that council indemnify the mayor for the amount that's being asked for, and I do have a mover for that motion. I think the information that Diane has provided is very clear that Mayor McCallion moved the motion at the council meeting in order on the request of the city of Brampton, and had that request, the motion and the request that came specifically in writing, walked on by the city of Brampton that day. Had that request not come forward, such a motion would never have been moved, or probably never have been moved at the region. We are, as members of council, we are very vulnerable to someone who is going to jump, or anyone who is going to jump on one little action that, no matter how serious it is, takes someone to court, usually under Municipal Conflict of Interest Act, and costs them hundreds and hundreds of thousands of dollars. And it's too easy for that to happen. The Mississauga Inquiry was a $7 million fiasco that cost the taxpayers money and resulted in nothing. And this was another situation that the mayor was put into at great cost to both emotional and financial cost. Unfortunately, at the Region of Peel, we only have insurance policies that cover and indemnify up to a certain amount. That amount was $50,000 up until July of last year when the premium was renewed, and staff realized that we could increase to $100,000 at no additional cost. $100,000 is basically a drop in the bucket these days, as you can see. And I don't know if any of us could be sitting here with a bill of $500,000 or $600,000 legal fees, be announced that you did not have a conflict of interest, and not get help from the municipality that you were representing as a duly elected official. It could be anyone around this table that is sitting here. And, we have always been very supportive of our colleagues in the other municipalities and of our citizens. But I can tell you that, all around Ontario, municipal politicians are looking and saying, well, maybe we should just shut up and not say anything, because you could get into hot water very easily, and not of your own doing. Having said that, we have the report that came forward has given council, which we got a week ago, and we got all the information that Diane provided today a week ago. So all the information has been in our hands. The bylaw that we have on the books at the Region of Peel, 382005, very clearly says that council can pay the cost of the legal fees under the municipal conflict of interest, if it's a municipal conflict of interest issue. It covers anything else. Municipal conflict of interest is exempted under the general bylaw, but there is the opportunity for council to use its discretion. And as Diane has pointed out, councils in other municipalities have used their discretion several times to do that, to support their council. It's my understanding that that in the city of Brampton, you actually have a policy that Councillor Paleshi was advising me of, that if the councillor is found innocent of the case, that the city of Brampton will cover the court costs. We don't have that in Mississauga. We do not have it at the Region of Peel. And I think this, now that this has come forward, I think we need to have it at the Region of Peel. I can only speak regionally right now. I think we need it in both municipalities. We also have under, according to Patrick, under the Municipal Conflict of Interest Act, a municipality also has the opportunity and the right to indemnify costs if the person is found not to be in contravention of the Conflict of Interest Act. So it's not that we are going beyond what we are permitted to do. The law very clearly states that municipalities can do this. I was prepared, as was Mayor Morrison, to move the motion today to pay the costs, and the costs that the court awarded, which was $394,000 and some. Having spoken with, I'm not one that goes around lobbying people, and you all know that. You know, I take my colleagues at face value and hope that the arguments will speak for themselves. But I have been approached by some of my colleagues in Brampton and Caledon who have asked for more information. They want more than what was in the report with regard to the Municipal Conflict of Interest Act and the ability that it gives us to pay the costs, and also more with regard to bylaw 382005 and that clause that says that municipal council can use its discretion. So I am prepared to not move my motion today, to ask staff to make the motion instead that staff bring to the next council meeting, because I don't want this to drag on, but the staff bring to the next council meeting a further report that goes into detail what we are allowed to do under the Municipal Conflict of Interest Act, what we are allowed to do under bylaw 382005, and further, and I know this is going to be tight timing, but I know you've looked into this, Patrick, through over the past months as you were preparing this request, that staff bring forward, and maybe using the City of Brampton as a model, policy as a model, a policy that we can adopt at the Region of Peel that will cover all members of council in a circumstance like this, and have that policy on the book so that the next time someone wants to cause trouble for a member of council, and that member of council is found to be innocent of the charges, that we don't have to go through all of this, that we have a very clear policy that is right here on the books of the Region of Peel that will cover it, and that new members of council, if any are coming in, and we know there are going to be some retirements, that anyone coming on to this council is very aware of what that policy is. So I would move, fortunately I've been trying to formulate that so I don't have it in writing at this time, Mr. Chairman, but my motion basically is that legal staff, and I think Mayor Morrison is seconding it, that legal staff prepare, and Patrick, could you just confirm, can you do it for the next council meeting? Okay. The legal staff prepare a report for the next council meeting outlining the specifics in bylaw 382005 as it relates to council's ability within the bylaw to indemnify the costs of a member of council charged under the Municipal Conflict of Interest Act and declared not to have a conflict of interest, as well as the ability given within the Municipal Conflict of Interest Act for council to pay those costs, and further that staff bring forward a policy to regional council that would state clearly that the region, in those cases, that the region would cover those costs. I don't have that wording down exactly, so I'm going to ask for staff's help on that one.
Hey, maybe I'll just go through the list of speakers.
Okay, so I would move that motion, though, Mr. Chairman.
Well, I'll take it as motion on the table.
On the table, if I could table that. Thank
and
you.
I'll deal with it then after I go through the speakers. Councillor Miles.
Thank you very much, Mr. Chairman. I'm assuming we're going to bring the report forward that deals with this item from staff as well. Okay. Yep. I don't have a lot to add to the comments that Councillor Sato has made, because I do absolutely agree with what she has said. When I originally looked at the request, it was like, it sort of took my breath away, but I've given it a lot of thought, and I've also read the report that has been provided to us, the letter from the lawyer as well as the report. And I do think it's quite clear that members of council do have the right under the bylaw to indemnify the mayor. And I am absolutely prepared to support that. I don't have any problem. After giving it a lot of consideration, I put myself in Mayor McCallion's shoes. And I know that if I was in her position, that this kind of action would absolutely debilitate me and my family financially. So we are at great risk as members of council, and it would appear as time goes on that risk is getting greater. We tend to be targeted by one and all. We're certainly painted with a brush that we're, in a lot of cases, just dirty, rotten politicians that are out to serve our own needs, and I think that's very unfortunate. And I do think it's really unfortunate that Mayor McCallion, after many years of service, ends up in this position. And so I do support it. You know, I guess the other thing that I think about is not only the fact that any one of us could be in the same position as her, but we're human, and we deal with a multitude. I don't think there's any other profession in the world or any other job in the world that deals with such a wide breadth of services and responsibilities, from works and roads and water and childcare and planning, and it goes on. And we also have a very rigorous schedule, and we don't always have the time to do due diligence with our agendas, even though we try. So at any time, any one of us could be in a position of conflict of interest and not even know. So that's what concerns me. It concerns me, number one, that we're vulnerable and we are at risk. And it concerns me that you could be guilty but not even know you're guilty, because you walked into a situation. If you're 5 minutes late for a meeting and something was added to the agenda, you could walk in, sit down, and not realize that you're in a conflict of interest situation. So I think it's absolutely essential, as Councillor Sato has said, that we do have coverage. Otherwise, who is going to want to do this job? I mean, most people don't want to do this job anyway. I mean, who in their right mind wants to do this job? Really, you know?
They want it.
Think about it. Who wants to do it?
They want it. They think it's easy.
No, when you look at the general population, I have people tell me all the time, I could never do your job. It's impossible. So we have to ensure that we do have the protection, and I think for our future we want to ensure that being an elected official is something that people feel proud of, and that people are not afraid to venture down that road because of liability and risk and everything else. So, I mean, we're we're supposed to be the ordinary Joe on the street representing the community. We're not expected to be, with all due respect, lawyers or engineers or anything else. We're just supposed to be individuals who are representative of the public that come forward and do our absolute best to make sure that the community is well represented. And I believe Mayor McCallion, she does that, and she absolutely deserves to be looked after in this instance. But I think all members of council should have that same opportunity. So Councillor Sato, if you want to refer it, you can refer it, but I think you may find that you have the support today to put Mayor McCallion's mind at ease, and also to ask staff to come back with more information about the future.
Councillor.
Thank you.
Thank you. Mayor Fennell.
Well, thank you, Mr. Chair, and I certainly support the intent of where we're going, and I certainly support what Councillor Sato has put on the floor. Just for some modest clarification, I think it's very important that we note Mayor McCallion was found not guilty of a conflict of interest, and there's a little bit of dialogue around here that, had Brampton not, she wouldn't have been surprised. Hazel McCallion is never surprised. The motion that Brampton Council walked onto their own agenda in 2007 was to meet a tight deadline for the regional bylaws. It was properly moved and seconded at the City of Brampton in 2007 on September 12th. It was part of the motion, then went in consent, properly moved and seconded, and it was a draft resolution to the Regional Development Charges Bylaw, a law of general application, that it was to be sent over to the region. It was put on the consent agenda, added on the council agenda, and sent here the next day. The clerk prepared the motion. I signed it, Mayor McCallion signed it, and it was found not guilty. Whether it had been here 2 weeks ahead, 5 months ahead, there was no conflict of interest. That was the finding. I just want to be clear about that, because there's a series of actions that, in fact, just last September, we did the same thing at Brampton Council table. Same councillors moved the motion on the renewal of our development charge bylaw for our central commercial area be different, and then it was to be sent to the region appeal. Same thing. We do it every 5 years. It's how we do business. So I just wanted to make sure everybody was clear that it's the business that the city does with the region appeal, and it was a not guilty finding. Thank you.
Councillor Crombie.
Thank you, Mr. Chairman. I think I'd like to speak a little bit about a personal experience, and that was after the by-election. I too was facing spurious, baseless, politically motivated allegations. Twice taken to Election Finance Committee, twice the Ontario Appeals Court, and then our judicial review was called for. I faced $50,000 in legal fees and never even entered a courtroom, and no one ever charged me. So it's very easy to see how quickly your legal bills can escalate in this very litigious environment. So just want to recap a little bit too. We know the judges agreed that the litigation was politically motivated. It did not arise from a bona fide concern for the public interest. The conclusion was inescapable that the action was more about tarnishing our mayor's legacy and her reputation than about municipal law. The mayor was awarded damages of $170,000, and the applicant refused to pay. He says he's impecunious, unable, whatever. Once again, the court found that the mayor did not have a conflict of interest, notwithstanding that, yes, the application was out of time, but she did not have a conflict of interest. This is very important. If any of us worked in a corporation today and we were directors or officers of that corporation, we would be fully indemnified. Absolutely, completely, 100%. If we were found not guilty And such should be the case for all of us as regional councillors. So what I'm proposing is perhaps there's a flaw in our policy here. Certainly we understand that there is indemnification available to us up to an amount of $100,000. I'm suggesting that that's not nearly enough, and we should be rendered whole should we be found innocent in any hearing, in any trial. If that's only fair, that would be with the same rule that would be extended to us, same coverage that would be extended to us, the same indemnification that would be extended to us should we be officers or directors of a board of directors in a corporation. And I don't see why it should be any different. I don't see why the rules should be any different for us as regional councillors. So perhaps we need a policy modification. And perhaps that should be the first step here, that we are rendered fully whole, that the policy be modified, and then we can entertain Councillor Sato's motion, which I intend to support in any case. And I think that bylaw 38-2005 should include all allegations, including Municipal Conflict of Interest Act. I think bottom line is that if we're found not guilty, as Mayor McCallion was, we should be rendered whole. And we should be fully indemnified as any director or officer would be in any other corporation in a similar circumstance. Thank you, Mr. Chairman.
Councillor Palashi?
Yeah, thanks, Mr. Chairman. I did have a discussion with Councillor Sato out back and about the issue at the City of Brampton and the policies of the city. And I don't believe, Pat, you could check, Patrick, I don't think we have a dollar maximum amount at the City of Brampton. When I had talked to Pat, and that was the reason I was saying that there is a policy. I went through one 20 years ago, Project 80, if some of the ones that are around remember that witch hunt that went on throughout the two regions. MOU, the former mayor, Peter Robertson, and accusations were made, and we didn't get to the court system, but we certainly had to hire legal counsel to represent us in the Project 80 investigation. And when we were found that it was absolutely false, or I don't know, whatever you want to call it, frivolous, the accusation. And I'm speaking in my case, and that I'm not going to speak for anybody else's cases, but Peter was the same, and we were both found that it had no merit. And so we had legal fees, and we were told by the city that if you have legal fees and you're dealing with that on accusations and you're found not to be guilty or not even charged, because the investigation actually cost you my money, cost my business money, and that the city paid. And I worked with my bills, and absolutely there was no question that the city paid those bills. And I truly believe that it's the same situation here. I agree with the previous speakers. It's a tough job to do. We all do it, though, knowing that. But then there are issues that come up, and when things that you're charged with and you're found not to be guilty, or doesn't even get that far, and there are costs incurred in doing that job, then I fully agree that it should be reimbursed. I also agree, and I said to Pat, that the issue is that we need a proper policy here at the region, and that to deal with that. And I don't think there should be a dollar cap put on that. The policy should be that whatever the charges are, if you're found innocent, then you should be, as you say, found fully whole in what the costs that you incurred in doing your job. You're absolutely right. Corporations do it. I thought in the case of City Brampton, I think it's under our policies and insurance, and whatever the limit is they do, then the city would pick up the balance type of thing. And so I absolutely believe that there should be a policy, and I fully support the reimbursement of the cost for the mayor. Thank you.
Mayor Morrison.
Okay, thank you, Chair Cole. I was more than willing to second Councillor Sato's motion, and I will second this motion. As Councillor Palashi has spoken, and Councillor Crombie, about having some personal experiences, I'm sure everybody around the table knows the wonderful experiences that I've had over the last 7 years. And I do believe that you cannot be held to pay those amounts, because that's what those people are trying to do to you. they're trying to bankrupt you, or they're trying to make you suffer within your family and your personal life. So I totally support the approach that Councillor Sato is taking and where we're going with this. I believe that there should always be some sort, if you are not guilty, there should always be some sort of indemnification for the politician. And let me tell you, folks, around this table, it could happen to any single one of you at any time. I agree that with Councillor Miles that the way the vindictiveness of some of the residents, and it just doesn't make sense to me. It's like poison spreading throughout the community. And what a shame. What a shame. And Mayor McCallion has served this region, has served her community, Mississauga, and this region for over 40 years. And she has done an outstanding job. And I have absolutely no problem with supporting her in this. I will say, much to my chagrin, I'll be in Ottawa at the next council meeting on municipal business, so I'm afraid I won't even be here at the table, but I think the approach Councillor Sato is taking, I would expect almost everyone around this table would support that. I certainly would if I would be here. Thank you.
Councillor Carlson.
Thanks very much, Mr. Chair. It's been a very interesting discussion, and I'm always reminded of how hard it is to do new policy on the fly, and that when you're presented with a conundrum like this, to try to do the right thing to indemnify someone who was wrongly accused, and at the same time come up with a method that will protect the public interest, which includes the ability of citizens to bring forward legitimate complaints, and that they have a way to feel confident that the court system will hear their case and be able to do it without costing them their house as well, because not all politicians are innocent all the time. So bearing that in mind, to come up with a policy that will cover us off for all the reasonable expenses and maybe some sort of case management, because if we think we have unlimited funding, we might avail ourselves of it and just grind out very high legal bills as well. So I'm very concerned at that I don't necessarily think there's a cap, because seeing bills from lawyers at City Hall and everywhere, I'm astounded at what it costs for legal representation. Certainly $100,000 is probably a will and a cup of coffee with the average lawyer these days. But there has to be a balance with that public interest, and that's the part. I'm not necessarily talking about this case, but in general, to provide an opportunity for the public to bring forward a legitimate case, and there have been some without naming any. I myself won a case similar to this 20 years ago. It cost me $100,000, and the person that I was involved with went bankrupt, and it was the same story. So I'm familiar, except they didn't have a program back then. The program was work longer hours and pay the lawyer off, so I'm familiar with that program. So it's hard to do this on the fly. One of the beautiful things about lawyers as well that I love is they've got three different kinds of billing going on at the same time. So you've got the retail, and then the wholesale you provided to the judge, and then the judge whittled it down to $170. So unlike other businesses, it's a bit of a moving target. So I'm a little concerned about that we didn't get the best customer price here. So that part with dealing with public money, I bear that in mind. But that's something we could think about over the next couple of weeks. But definitely leaving this where it stands for any one of us, we're sitting ducks at that kind of a level of support from insurance and from the general taxpayer. I'm wondering too, when we're talking about corporations covering us unlimited fashion, they probably provide the lawyers as well. So we're free to do whatever we want. So as far as hiring someone, so if we're going to raise the cap, then I'm assuming we're going to need some policy governing, how it's not just handed out to. Just give us the bill at the end, we'll cover the tab. So it's a substantial amount of money we could be talking about over the next few years. So I support the deferral, because I don't know how you're going to hammer it, even the beginning of that out in the next week or two, but I'm willing to hear all the arguments on both sides. So those are my comments for the time being, and I look forward to seeing this resolved properly. Thank you.
Councillor Unica.
Mr. Chairman, I'm grateful for the discussion, and I'm grateful for the approach, because in all candor, I most assuredly could not have supported the motion today if it was to indemnify, and my rationale is very simple. I can read the English language, and I can read our policy, the one that was just minted a few months ago, and it says the cap is $100,000. There may be all sorts of reasons why it shouldn't be, and I get that. And I think what we're saying is let's have some of those reasons. But to the point that's being made, notwithstanding some of the revisionism, the policy itself says, and some of you are belaboring it, was found innocent. This is what your policy says. The coverage applies to both guilty and non-guilty outcomes. I'll repeat that. The coverage applies to both guilty and non-guilty outcomes. You can spend all the time, well, innocent doesn't matter according to your policy, apparently. I don't know if some of you are aware of that. Maybe you want to revise that, but be that as it may. The fundamental point that I'm making is it's very, very clear that the limit of the coverage was increased at the time of the region's annual insurance renewal from $50,000 to the then maximum coverage available from the region's insurance provider of $100,000 effective July 1, 2013. That's the last time we turned our minds to this. It isn't a year. So if one of my constituents is reading this, assuming they can read, they say, Nando, how did you hand over a $500,000 check? Well, I can't read, or there's something else going on. And what this report doesn't do, and I don't think it can, and I think, Bonnie, you're right, you've got to bridge the gap to say, because I've never been in this situation, hope I never will be, but I have to agree, I don't think $100,000 gets you much in the modern era. What we have is relative to a policy, the practical application of how it played out. And this is the real world, and these are the numbers involved. And I think it's clear there's a disconnect, but that has to be explained and documented so that we can rationalize and revisit the policy. The final point that I will leave you with, and you may disagree, but I'm going to give you an apples to apples, not an apples to oranges. As an apples to apples, the Canadian dollar's gone down dramatically. One of you goes on a conference and says, my $60 per diem just doesn't get it done. That pays for breakfast in Tokyo, so I spent $300 a day in my per diem. Mr. Chairman, I don't think you'd hand over the $300 per day check. You'd say, well, hold on, it's $60. Oh yes, but you'd say, no, I don't care what you, if you want to revise the policy, bring that back and say, 60 Canadian dollars doesn't get it done. We wouldn't just say, well, but in fairness, he's got the chits, so let's just give him $300. You can't. And it may be 60 is inappropriate. It's the exact same principle that applies, and I agree fundamentally the policy is inappropriate. So bring that back and say, and as an example, here's one, and isn't this the right thing to do? And under those circumstances, I can explain it to my constituents and may find favor with the motion. Thank you, Mr. Chairman.
Councillor Mullen.
That's it.
Thank you, Mr. Chairman. I'll be very brief. First and foremost, I guess, to open, how sad. How sad that we're even dealing with this. And to you, Diane, thank you so much for coming today. For those around who do not know who you are, you have been certainly a major community volunteer in the city of Mississauga for many years, and it's very appreciative that you would come forward as a resident and as being so well known to come and speak on behalf of the mayor. So thank you. And I think thank you to Councillor Sato for bringing forward the motion. I agree, and I think that you said it so well, Councillor Miles. To put yourself in this position has to be absolutely devastating. And to have the risk of losing your home after 40 years of service, it's just unacceptable. It's appalling. It's incredible. So I agree. To put yourself in the position that she is in today, and for some of you who have already been through it, Councillor Crombie and Mayor Morrison, I know what Mayor Morrison has gone through, and it just takes everything out of you, and yet you're still trying to do the job. What Mayor McCallion did that day was try to benefit the requests from Brampton and from Mayor Morrison, from Caledon as well. Certainly, a process is important, and I think that's what we're talking about here today. So I am going to support Councillor Sato's motion. I think it's appropriate. Let us get it back here at the next council meeting, because I don't think Mayor McCallion should have to go through any more in terms of what she has gone through in terms of this ordeal. So I'm fully supportive.
Hey, could I have the motion on the board, please? I can read what I have. Is that what's going to be? All right, there it is. Everybody had time to read it? Okay. You have a question on it? Yes.
The question is, why are we limiting it to the municipal conflict of interest?
Councillor Sato?
Thank you. It's relating it to the Municipal Conflict of Interest Act because that's what bylaw 382005 relates to. And that is what the insurance under item 4, conflict of interest reimbursement, is specific. The insurance that Councillor Yanika was referring to was not the conflict of interest insurance. Conflict of interest insurance does not cover, it doesn't relate to guilty, not guilty. It's a different insurance. So specifically, we are covered under the other policies for example, the Ontario statutes, and Patrick can explain that. The amounts that we are covered for, certainly in the report that comes back, can be extended or can be looked at being extended. But in this case, it is the Municipal Conflict of Interest Act that is the only one that is under Council's discretion to pay the fees for. So that's why this is relating specifically to that.
Okay, Mayor Morrison?
I was just going to say, having had some experience in this, that the insurance companies for, I would assume the region, but the municipalities will determine whether you can be covered under their policies or not, but not for conflict of interest. It's all the other things that you do, because when I was sued by a developer, it was not a conflict of interest lawsuit, it was a suit for some other stuff. And I was covered under under the legal for the insurance coverage for the town of Caledon, and had legal on that side. So,
Councillor Carlson?
Not to belabor, but if we could take it as direction that you would look at the nuances of the guilty, criminal, because, I don't want to explain why we paid $1 million for somebody guilty of fraud or something. That's one thing that comes to my mind. And secondly, any other related issues. I'm sure you know the business and what's going on in Ontario, so this is a good start, but I don't know whether we can do all this by next week or 2 weeks, but a picture of how we can protect ourselves reasonably in all aspects, whether it's civil, conflict of interest, or criminal, and that we're not seen to be circling the wagons for every illegal eventuality for criminal, non-criminal, etc. So, I don't want to put the needle at the other end of the gauge here either. So I think there's got to be a little fear of something to the average politician. Otherwise, so I don't know. I just saw that as direction.
Okay.
I'm sure you have associations that deal with this stuff, and
Solicitor Patrick, do you want to speak to that?
I wanted to say that I'm in support.
Are you the solicitor now?
Oh, sorry, I thought you were a good one.
Looks like a judge.
Mr. Chair, I just wanted to offer the comfort, if you will, that there is broad existing coverage under the policy that is the subject of the report on the agenda today. The difficulty is that policy, as it's currently written, carves out municipal conflict of interest, and instead of making it an entitlement to claim indemnity, it affords council a discretionary decision in a municipal conflict of interest case, and that's the discretion that is being asked of you now. So there is a broad coverage for these other non-municipal conflict of interest act type exposures that you can rely on the bylaw for. The second thing is, I'd just like to emphasize that in addition to the bylaw itself, the Municipal Conflict of Interest Act, a provincial statute, does provide council with this discretion to afford coverage in an appropriate case. So that's a separate legal foundation for what you're being asked to do.
Are you happy with that? That's correct. Okay. Councillor Patrick.
Thank you, Mr. Chair. I just wanted to say I'm in support of the motion, and I appreciate the philosophy behind it of getting a little bit more information, of clarifying that we take away that discretion in an omnibus sort of way, because it's an election year, and inadvertently, if we were to deny this or be in a position to deny this, we are dissuading people from coming forward to run for election. I think Gail made a good point about how crazy we all are. And people tell me that all the time. I mean, it's I would never do your job. So I think it's important that we give everyone out there the feeling of safety that you can do this job. If you're doing it conscientiously, you won't be ruined.
Okay. Councillor Moore?
Thank you, and I'm going to support Councillor Sato's resolution, but I have a request through to legal. When you draft the report, could you please put it in layman's terms? I understand you like to write things in all these legalese, and it's important, I guess, for the public record, but honestly, I would respectfully ask that it be put in layman's terms, and if appropriate, could you please do a staff report? You've given us information today that outlines things, not a staff report, a presentation, a brief presentation, so that we see it there, but not just us, but anybody who is watching council, because we're now televised, will be able to see and understand, and it's not just trying to connect dots between comments made around this table and a report that's sitting in front of us. So I think a presentation in this case would be most appropriate. Thank you.
Okay, Councillor Sato, last speaker.
Thank you, Mr. Chairman. I just wanted to ask for, because Patrick came over, and the next council meeting is on February 27th, and I realize that this is a tight timeline. However, the one after that is not until March 27th because of March break. And quite honestly, I think we need to deal with this issue as it regards the indemnification of the mayor's costs sooner rather than later. And to leave it to March 27th is putting it off for, almost a full month. And I just don't think that's fair to do. So his concern was that the timelines to getting the report to clerks, the agenda timelines were going to be difficult for him. So I would ask for some discretion and leeway in the clerk side and David, the CAO side, to allow that report to come on February 27th, because I do think it's very important. The report can be written, but it's getting it into the clerk to meet those deadlines is in 2 weeks is going to be tough. So if you could help out, that would be.
Mr. Chairman, we can certainly change the internal processes. The concern I always have is that we don't get the report to members of council soon enough so that you can make an informed decision. So what it probably means is the report itself won't come to you until probably the 25th, just 2 days before the meeting.
Well, I think that's fine.
If that's okay with you, then we can do that.
I think that's fine. And Mr. Chairman, I would ask for a recorded vote, please, on the motion.
Yeah, just one point. Because we've never funded for this, I believe that what we would do as staff is look at 38-2005, and we would have to allow ourselves to take that money out of reserves in order to be able to do that. If that was just a small thing to give staff a bit of an advantage of where the money would come from, and then you don't have another concern when we come back. Okay? Councillor Mullen.
I was just going to call the question and a recorded vote.
Okay. All those that are in favor, will you please stand? There's this motion on the table here.
All those in favor, Councillor Carlson, Councillor Crombie, Councillor Dale, Mayor Fennell, Councillor Foley, Councillor Fonseca, Councillor Hames, Councillor Ianica, Councillor McFadden, Councillor Miles, Councillor Moore, Mayor Morrison, Councillor Mullen, Councillor Palashi, Councillor Paderak, Councillor Sato, Councillor Sanderson, Councillor Spovieri, Councillor Starr, Councillor Thompson, and Councillor Whitehead. It's unanimous. Thank you.
Thank you very much. Could I have two motions, both appreciation of both candidates to be here today for the presentation? All those in favor? Thank you very much. Thank you. Okay, moving on then to the agenda. Now we have an agenda. So we're into proclamation. There's one proclamation. Could I have a mover and a seconder? Okay, Paleshi and Sanderson, that the February 22nd, 2014 be proclaimed as